Good morning, everyone. My name is Kim Bailey with Alzheimer's Orange County, and I'd like to welcome you all to today's webinar, Legal and Financial Considerations in Dementia Care. And we thank you so much for being here. These complimentary webinars are brought to you through an ongoing collaboration with our sponsors. We have Chatterton and Associates, the Wealth Management Team, Care Choices, Hospice and Palliative Services, Caring Companions at Home, Chatterton and, O'Connor Mortuary, and also Alzheimer's Orange County. And our sponsors are providing these webinars as a service to the community on topics that are beneficial for anyone who cares for and works with older adults. And we hope that you find them useful and informative. And with that, I'm going to go ahead and introduce you to our expert speaker today. She is Christina McGonigle, and she is she's a managing partner at McGonigle and Hunsaker. She graduated magna cum laude from Western State University College of Law and received her bachelor's in political science, again cum laude, from Cal State Long Beach. Ms. McGonigle is certified by the National Elder Law Foundation as a certified elder law attorney. She is also a member of the National Academy of Elder Law Attorneys. She's on the board of the Orange County Bar Association section on elder law and special needs, as well as the probate section of the Legislative Resolutions Committee. Ms. McGonigle practices in the areas of trust and estate planning, special needs trusts, trust administration, conservatorships, litigation, and Medi-Cal applications and appeals. And she has a great deal of knowledge and her expertise to share with us today. And we are just delighted to have you with us, Christina, today. So with that, I'm going to go ahead and turn the presentation over to you. And thank you so much again for being here today.
Well, good morning, everyone. I'm especially happy today to be able to reach out to everyone in these tough times where we don't have a lot of contact. I'm just really grateful for each and every one of you joining us today because we're going to talk about some things that are really important, sometimes difficult and sometimes uncomfortable, but it really matters. Why? Well, because in estate planning, we have the opportunity to let our loved ones know our wishes. And this is beyond just leaving a legacy of our personal property and our finances. This is expressing our wishes to those who care for us. So this all too often is the complication that I come across. As an elder law attorney, I serve everyone. However, I specialize in planning for incapacity. I specialize in planning for you during your lifetime. But all too often, folks put it off until it's too late. And for me, what is too late? Well, when a person has not the capacity to make the plans, put into place the wishes that they would like to express to others. But let me emphasize, just the diagnosis of dementia alone does not mean that a person lacks capacity. Capacity is measured by each individual activity. There's the capacity to enter into contracts, dealing with your brokerage account. That's the highest level of capacity. Then there's the capacity to make a will or an estate plan. All you need to know is who's your family, what do you own, and that you're creating an estate plan document at the time that you sign it. That's kind of a low level of capacity. And then the very, very lowest level of capacity is the capacity to marry or divorce. And the law now says that all you have to do is be breathing and be able to say yes or no. So what is the alternative to estate planning? And unfortunately, it is a court-ordered substitute for your estate plan, the conservatorship. We disfavor conservatorships. They're a great safety net when there's no alternative, where we have someone who needs care, who needs their estate managed on their behalf, but they've done no estate planning. But we don't want to plan for that unfortunate, intrusive, and expensive proceeding. Once there's a conservatorship established with the court, it's very public. It's under the court supervision for the remainder of the person's life. And so what we want to do is avoid conservatorship, and let's talk about the ways that we do that. So for the first half of our presentation here, we're going to talk about the estate plan documents, the essential estate plan documents. And there's 4 main documents we need to discuss. The first is the Advance Health Care Directive. We will also discuss the power of attorney for finances. And those are, to me, the most important documents because they directly affect you during your lifetime if you should become incapacitated. We will also mention the will, but because it does not come into effect during your lifetime, we will spend very little time discussing that, but we will discuss the revocable living trust. So those 4 documents are your estate plan arsenal. In the second half of our presentation, we're going to talk about planning for care. I'm going to spend a lot of time on Medi-Cal for long-term care in a skilled nursing facility. Those are questions people always have because that is our largest public benefits program to deal with end-of-life care. However, there's a few other options that we will discuss. So first, for our first topic of the Advanced Healthcare Directive, what is it? Well, it is a statement of what you want if you become incapacitated, cannot discuss with your doctors and hospitals how you wish to be cared for. And as mentioned, one of our program materials, you see a picture of it right there, is the 5 wishes. This is actually an advanced healthcare directive, legally binding, that you can create right now. How do you make it legal and valid? The signature page must be witnessed and notarized. Okay, so we had said that you express your health care wishes in your advanced health care directive. What types of decisions are you empowering your selected agent? It would be what types of treatments. For example, some folks have faith-based objections to certain medications or transfusions or certain procedures. This is where you would state that. Another very important type of decision that can be made under the Advanced Healthcare Directive is placement. You can state your preference for facility or placement or care. But also, this is where you can state your end of life wishes, not just whether life support is agreeable to you, but also disposition of remains. So these are all very important decisions to make that is very helpful to your loved ones. So the most important decision, I think, is who do you select to make these decisions to communicate your wishes to hospitals and doctors? Well, it's got to be someone who's got a strong sense of loyalty to you. They've got to understand your wishes and desires. This is somebody that you've communicated these wishes and desires to, but also somebody who can make a real tough choice in really tough circumstances. This is the person who's going to have to make end-of-life decisions on your behalf. So how do you prepare them? Well, I think there's a couple of really great conversation starters, and that's why we like the 5 wishes, because it does have questions that make you really consider, what does the person standing in the shoes of the agent need to know about you? What do they need to do to best serve you? Other really good resources are, there's something called Your Way. These are all resources available online. And the same thing, it makes you go through a lot of different considerations. But what I think would be most important, because there's so many things that you've never thought of. For example, if you cannot communicate your dietary restrictions, if you cannot communicate your desire to wear socks or not socks, or be covered up or not be covered up. These are things that you can touch upon on these more extensive um, um, addendums to your advanced healthcare directive. But at least pick out at least 3 really critical, important things to you, things to discuss. For example, one of the things that I'm finding that clients really want to emphasize is either their faith-based beliefs as they relate to healthcare. Pain relief is the next most important thing, and maintaining quality of life. Okay, so we've just covered the first most important document, which is the power of attorney for healthcare, also known as the Advanced Healthcare Directive. The second most important document that affects you during your lifetime is the Durable Power of Attorney for Finances. This is where you have appointed someone to stand in your shoes and conduct business on your behalf, even if you have become incapacitated. So this is only for you during your life. The documents that affect you after you have passed away are the will and the trust that we will be discussing momentarily. So the power of attorney for finances allows someone to stand in your shoes and conduct business on your behalf for your benefit. One of the things that I have heard people say that they're very concerned about is they've heard stories of a person or a friend giving power of attorney to the children. The children then take all her money and assets and place her in a facility. Well, let me emphasize that the agent under a power of attorney is a fiduciary, that they are to manage another person's money and property for that other person's benefit, not for their own benefit, and taking any actions that are not specified under the document is actually an act of financial elder abuse. So a power of attorney is not a license to steal. People ask me, so where do I find this document? And yes, they are available online. They are available at stationery stores. But what I have found is many banks and institutions are very, very hesitant to accept these. A power of attorney that doesn't meet the bank or institution's criteria, it will be rejected. And I've had a few folks who actually had powers of attorney who needed conservatorships because their bank or institution did not accept their document. So the best chance you have for having a document that will be accepted by banks and institutions is to use the statutory form. This is known as the Durable Statutory Power of Attorney for California. Make sure that your documents, if you have them, are California specific. But more reliably, to get a power of attorney that will be accepted by banks and institutions, you would probably want to have it attorney drafted, because it is not a one-size-fits-all document. Many of the statutory forms do not address what we need to talk about when we're looking at long-term care planning. And we'll talk a little bit more about that towards the end. One of the things that I always look at when I'm reviewing someone else's power of attorney document is, what is the agent permitted to do? Is the agent permitted to make decisions about placement and care? Is the agent allowed to make decisions about long-term care and Medi-Cal planning? And for older documents, generally the answer is no. And for online documents or pre-purchase documents, generally the answer is no. Okay, so with we've just talked about the durable statutory power of attorney. We've just talked about the advanced health care directive. I said those were important because those are for you for planning during your lifetime. Now we're going to talk about the will, which is only good for you after you have passed away. So what does it do? It merely disposes of property. It doesn't give anybody the ability to do anything for you during your lifetime. So the question I hear most often is, when do I need a will and when do I need a trust? Well, if your property is worth less than, not 150,000, update your slides, everyone. This just changed this year. If your property totals less than $166,250, then your estate will not be probated and you can use a will. However, if your estate is worth more than $166,250, for example, anyone who owns real property in California, then your estate shall be probated. And probate is a bad word, just like conservatorship, because it's expensive, it's time consuming, and it's public, and it is under court supervision. Then it's rather wasteful, I think, that if you could create a revocable living trust and avoid all the costs of probate, then why would you not do so? Presently, the cost of probating a single family residence in California is almost $15,000. That's terribly wasteful. Okay, so now I want to move on to talk about revocable living trusts. These are a really important tool for us, not just planning for what's going to happen to your estate after you have passed away, but also to provide management of your estate during your lifetime should you become incapacitated. But also, as of January 1st, 2017, this became our best tool for planning for Medi-Cal for long-term care, because the Medi-Cal estate recovery, which we'll talk about towards the end, does not apply to assets that are in trust. That's new. So what is a revocable living trust? Well, it's sort of an entity separate from yourself, almost like a corporation that you are the CEO of, and you are also the 100% shareholder of it. So think of it that way. It's an entity separate from yourself that benefits you, that you control. Why is it good? Because it avoids probate. Assets that are in trust are not probated upon your passing. What's more is it avoids conservatorship, because assets that are in trust can be managed by your selected successor trustee should you become incapacitated. So what is the trust document? It's 30 to 50 pages that does what? Well, it says, how is my estate going to be managed, by whom, and for whose benefit? What goes in trust? Money, property, brokerage accounts, anything. But the thing that does not need to be included in a living trust is anything that has a beneficiary designation that would not be probated, such as your IRA, your 401k, many annuities, and life insurance. Those things are not going to be probated, and therefore many of those things do not have to be in a revocable living trust. And what's more is IRAs, annuities, and 401ks cannot be owned by a living trust. And many of us have most of our wealth in our retirement accounts. So think about that in terms of who would manage that if you became incapacitated. That would be your agent under a power of attorney. What would happen to it after you have passed? That would be your beneficiary designation. It would not be controlled by a revocable living trust. So this is for all of those other things: real property, money, brokerage accounts, and personal property such as belongings. How is a living trust managed? Well, you are the trustor. You're the trust creator, also known as a settlor. The trustee is a person who manages the trust. That's usually you. And then you would also name successors. I recommend folks to name maybe 2 to 3 successors, because who you select now, well, if they're your contemporaries, may be unable to serve in that capacity when you need them to. So you want to ensure that there's somebody there to serve. I do get a lot of questions. People tell me I don't have any close relatives, or I'd rather my children not be burdened with this task, or I'm just far away from everyone. There is a new industry that has cropped up that I would say every other estate plan, a client of mine has selected a private professional fiduciary. These are people who are CPAs, financial advisors, sometimes even social workers who are licensed and bonded to act in the role of fiduciary. So don't let the idea of, I don't have anybody in my life to take this job, prevent you from doing this very important planning. Lastly is the role of the beneficiary. During your lifetime, you are the beneficiary of your revocable living trust, and then you have named also who would be the beneficiary after you have passed away. So, in creating a revocable living trust, we had said that you want to name not just one successor trustee, but maybe 3 potential persons who could act. Similarly, you must always state, well, what happens to my beneficiary? What happens if something happens to my beneficiary? Will it go from your children to your grandchildren? Will it go from a close personal friend to a charity? Think about alternatives, because how do you say, nothing is certain in life. We had said that your IRAs and your 401ks are not trust assets. And this is important. How do you get assets into trust? Well, you take your trust document on down to the bank and say, I wish to fund my trust. And they will then title your bank accounts in the name of your trust. How do you title your home in the trust? You sign a quitclaim deed and record it with the county to transfer your property into trust. Also, what we just mentioned about recording deeds on your property, what often happens is that when a person refinances, it is taken out of trust. And so the home is just left in the trustor's name alone. And if the person passes away before they have had the opportunity to transfer the home back into the trust, then they've passed away with assets outside of out of the trust, which could require a probate. But that's where our will comes in. Our will states, I give, devise, and bequeath everything I own to my trust, also known as a pour over will. However, we said that assets that exceed $166,250 require a probate if they are outside of trust. Well, in our case, where that happens, we would need a court order. Not a probate, but we would need a court order. So the message that I'm sending to you, those of you who have revocable living trusts in place, please check your asset designations. As in, look for your last recorded deed on your home. Check your financial statements to ensure that it states the owner of the trust is you as trustee of your trust. And for IRAs and annuities, make sure that you have the proper beneficiary designations. When should you review an existing trust? My experience is that trusts that are older than, say, 20 years ago have very archaic language. The laws have changed quite a bit that allow us to have more ease of administration. What we often did back in the early part of our century was to create AB trusts. Many of us have these AB trusts, and the purpose of that was to avoid estate taxes. Well, presently, estate taxes only affect those of us who have more than $11 million if we are single, and $22 million if we are married. I hope all of you have this problem. However, for those of us that don't, well, our old revocable living trusts are designed for a scenario where estate taxes would affect us. Back then, if you owned a home, estate taxes would affect us. But presently, only those of us with the problem of having $22 million are affected. So what I'm saying is that is one of the reasons why you should review your trust. And people ask me, how often do I need to do that? Well, I would say anytime you have a change in your family, anytime you have changes in your finances, if you've moved, if you've sold property, take a look at what does your trust say. Also, one of the issues that I have with many of the estate plans that I see is there's no provisions in there for long-term care planning. For example, what we were saying, that my agent can take steps to help me qualify for Medi-Cal, that my trustee can make transfers that are necessary to help me be eligible for long-term care. So with that, we've spent about half of our time looking at the estate plan documents, the things that you really should have in place, the advanced health care, the power of attorney, wills, if you have less than $166,000, or a revocable living trust. Okay, so the second half of our presentation is to continue on with the power of those documents that we just discussed in looking at the long-term care options that we have. So we know that aging is really expensive, and there's very, very few opportunities for public support, public benefits to help us with the cost of care. So independent living, that's a senior community. Respite care, that's a benefit of Medicare, so there is some coverage for that. In-home care, generally speaking, very expensive. I think the going rate right now is $30 per hour, and it's going up every year because of wage and hour laws in California. So that has made it very unaffordable for us. There are also tax laws in effect that do not allow us to avoid paying FICA for caregivers. The good news is there is a small program under Medi-Cal known as In-Home Supportive Services, IHSS, that provides a little bit of in-home care, but it doesn't even come close to what is needed. Adult day health care is another option that keeps people at home but pays for supervision during the day. It's a lot less than placement. However, there is a small limited program under Medi-Cal that does provide for the cost of the adult day health care. Assisted living. This is your boarding care. This is also your Atria, Sunrise, or Silverado level of care. It ranges Broadly, I think it starts at about $2,000 on up to $10,000 per month. There is a very small limited program under Medi-Cal known as the Assisted Living Waiver Program. It's very, very, very limited, and it's dependent on the facilities accepting the program. Next is the memory care, which is again the secure perimeter facilities such as Silverado or Sunrise that specialize in dementia care. And there is no public benefit program, no public benefit program that provides for this aside from the assisted living waiver program, which causes a big gap for people who need care but cannot afford the 10, the 15, or the $20,000 that generally is the monthly rate for memory care. Next, however, is long-term care in the skilled nursing facility. So skilled nursing homes, generally speaking, we go to rehab, we are hospitalized, we are discharged to a skilled nursing for rehab, and then we are discharged home with some supported services. But for long-term care, there is coverage under Medi-Cal. And finally, hospice, which is also a public benefit. It does not cover 24/7 care, but it does send in persons into the home for in-home care. So how do we pay for this? We were just talking about it could go from $2,000 on up to $20,000 per month to provide for care. Well, it's on us, folks, for the most part, for most levels of care. But we said that there is public benefits for long-term care and certain interim levels of care. Veterans benefits. The aid and attendance benefit can be very useful for providing for in-home care. There's also a county-based home housekeeping program. So what I would recommend for veterans is to contact your Veterans Service office to see if there are any benefits that can assist with long-term care. Okay, what does Medicare do? We all get it at age 65, but what does it do for us when we're looking at long-term care? And the answer is not very much. So we had said you can be hospitalized and then discharged into a rehab for skilled nursing care. But generally speaking, it only pays up to 20 days. And furthermore, after 20 days, there is a copay. But moreover, as most folks do not get their full 20 days, much less their full 100 days. Generally speaking, you'll get about 2 weeks, and then they'll say you're not making any progress, so you're going to be discharged. Folks ask me what to do in that circumstance, and that would be a Medicare appeal. That's going to go a little bit beyond our scope for today, but what we want to focus on is Medicare is usually the bridge that gets us into a skilled nursing facility for long-term care. Okay, so I kept alluding to Medi-Cal. What is it and what does it do? It's a state program for providing for long-term care. We said that there's many different programs. I named a couple of them. There's the adult day health care, there's IHSS, and there's the assisted living waiver program. Those are very, very, very limited programs. To find out more about them, what I would say is Department of Healthcare Services of California. That would be the source to learn a little bit about that. But as mentioned, disappointingly, it's not widely available, and the income limitations are so harsh that most folks aren't going to benefit from it. So most of us are looking for Medi-Cal for long-term care. All right, For Medi-Cal for long-term care, you must be in a skilled nursing facility. That is not boarding care. That is not memory care. That is a skilled nursing facility with doctors and nurses 24/7. And there must be a medical necessity, which would be a deficit in an activity of daily living. A deficit of an activity of daily living, which is bathing, dressing, feeding, ambulating, transferring, and toileting. So generally speaking, to qualify for Medi-Cal for long-term care medically, a person is incontinent and non-ambulatory. Okay, so often qualifying medically is far more challenging than qualifying financially, because for so many of our loved ones who suffer from dementia, they are physically very well. They just need constant supervision and constant care. However, our Medi-Cal program is not designed for dementia care. Our Medi-Cal program for long-term care is for those that need doctors and nurses for medical care 24/7. But the good news is once we qualify medically, because Alzheimer's in particular is a progressive disease that eventually has physical aspects to it, that by the time we are there, often a person does qualify financially. So what is counted and what are the qualifications? For a single person, one may have a home, a car, unlimited IRA or 401k, and up to $2,000. But for a married person, they can have a home, a car, unlimited IRAs or 401ks, and up to $126,420. So that's cash investments, anything that can be liquidated to pay for care. Okay, so we had said it's pretty easy to qualify for Medi-Cal for long-term care, but Medi-Cal is not free. So you can make unlimited amounts of income, unlimited income, and still qualify for Medi-Cal for long-term care. They just count what's in the bank and what other assets you have besides your home. But Medi-Cal is not free. You will pay your income to the facility as your share of cost, all of it minus $35. However, if you are married, then your spouse gets to keep an amount to add together his or her income plus the ill spouse who is going to the facility. The spouse at home can keep $3,161. The rest is paid to the facility as the share of cost. Medi-Cal is not free. Now, let's talk about qualifying for Medi-Cal. Do not try this in any other state. This is only Medi-Cal. Generally speaking, other states, if you transfer property to anyone else to qualify, you are going to be disqualified. And they look back up to the last 5 years to see, did you do any transfers? And you can be disqualified for up to 5 years. Here in California, we have a 30-month look back. And what do they want to see? Did you make any transfers that are more than $9,337. If you made any transfers, then you can be disqualified for the month that transfer happened. If you make gifts of less than $9,337 per recipient, per gift, as in you could do this every day and qualify for Medi-Cal. When telling folks this, I've heard the response, well, so are you saying I could get really poor really fast? The answer is yes, you can. The restriction here, however, is generally speaking, the person who needs Medi-Cal for long-term care often doesn't have the capacity to do gifts or make any of these transactions. And very often, if they had estate plan documents, maybe they had a power of attorney, maybe there's a trust, very often there's no Medi-Cal planning clauses in there. So very often I have families coming to me that need to qualify for Medi-Cal, and I have to explain to them, you can't do any of these transferring. You don't have anybody qualified or authorized to do these transactions. This person needs to pay privately until such time as they qualify financially. But for those of us that have done this type of planning, that it states in our powers of attorney or our revocable living trust, my agent can do these things for me to help me qualify, then qualifying for financially is generally very, very easy in California. Medi-Cal is not free. I had said that during your lifetime on Medi-Cal, you are paying the facility, the share of cost. Once you have passed away, the state of California will send you a bill. They will say, whatever you had left over after you have passed away, pay us. Pay us. This is your bill. Pay us from whatever the estate consists of. But we had said, as of 2017, there was a major change in the law. Anything that is in your revocable living trust cannot be claimed for estate recovery. So we have said that there's many, many reasons for us to plan for our future. We want our loved ones to know what we want, how we want to be cared for. We want to ensure that the persons who we wish to have as the subject of our bounty be named in our wills, but also for long-term care. Our powers of attorney and our trusts are the most powerful documents to achieve that. Now, being that we're running out of time, I'm not going to talk too much about the spend down suggestions, but being that we often have to have we don't qualify medically for long-term care, we would spend down by using funds for private interim level care. But remember, Medi-Cal's not a goal. None of us would opt to be in a skilled nursing facility if there were other options available. But it's a wonderful safety net for those of us who need it. So where to go about finding more help? Well, let me address that. You have received a wonderful flyer that lists all of our county resources. One of the best resources for you if you need help looking at an estate plan or Medi-Cal planning is right in the center of your page is the Orange County Bar Association. Those are attorneys that you know have education and are actively involved in their community. I do know that Alzheimer's Orange County does have a list of educators like myself that perform estate planning and Medi-Cal planning. Also, another wonderful resource for folks that you know are estate planners that specialize in planning for incapacity is the National Academy of Elder Law Attorneys. And in particular for planning for long-term care, I'm going to refer you to CANHR, which is California Advocates for Nursing Home Reform, CANHR.org. They have the best, most up-to-date information about Medi-Cal for long-term care. So my message for you is if you plan for the best and the worst happens, you are in very bad shape. But if you plan for the worst and you end up with the best, you are only slightly inconvenienced. Well, with that, I am concluding a little bit early so that we can have our question and answer session.
That is great, Christina. Thank you so much. That is a wealth of information. And I just want to take a second to, I don't know if my head is kind of spinning with all that great information. I want to remind all of our attendees that this session was recorded and it'll be put in our archive on our website. And so I know that I'm going to go back once it's archived there. It'll take a little while for us to do that, but I'm going to certainly go back and listen to this again and take more notes. And I advise everyone else to do that as well. And this is our opportunity for all of you to type questions into the chat box now, and some of you already have, but before I begin that Q&A session, I just want to remind everyone that we may run past the 12th or the 11:30 hour. If we do, you're welcome to remain online to listen in or to have your questions answered. If you do need to leave the webinar, you can. Just remember, everyone has to stay on for the full 60 minutes if you're earning CE credit. And I also, before we get into the questions and answers, I want to take a moment to thank our sponsors one more time for making this presentation and all of our presentations possible. So thank you to Chatterton and Associates, the wealth management team, O'Connor Mortuary, Alzheimer's Orange County, Care Choices, Hospice and Palliative Services, and Caring Companions at Home. And a reminder that we do this every month, and next month we'll have another great webinar, the title of which is Resiliency and Coping Strategies for Dementia Caregivers. And our speaker is Dr. Miriam Galindo. She's a licensed psychologist, also a licensed social worker and nurse with over 30 years of experience working in a variety of settings, as well as a background in personal caregiving, family caregiving. So that should be great too. So let's get into our questions and answers. Let me take a look at what we've got. All right, let's see. Our first, okay, I just have to expand my question box here. Okay, given COVID-19 and, oh boy, this is a tough question. Given COVID-19 and overwhelming morgue storage, do you think that cities are going to be able to observe a person's disposition requests? So this has to do with after a person dies and they're in the morgue, how are we going to be able to observe people's disposition requests? Wow,
Right.
I gave you a tough one right out
Oh,
of
yeah.
the gate there.
That's a heavy one, isn't it? Well,
Yeah.
here's the thing is I have not heard that there has been any difficulty in disposition of remains. Very unfortunately, during this period of time, I have been with loved ones who were administering estates, and each of them had their loved ones' wishes observed. So I have not observed any differences in the ability to have cremation for those with faith-based observances. I haven't seen any problem with a quick disposition if that is what the religious order requires. The other thing is, this is where your agent for healthcare, the power of your agent for healthcare really comes through. We had said, you gotta have someone who is gonna advocate on behalf of you. We gotta have someone in that role who's going to get in there and tell doctors, hospitals, more, etc., this is what we are doing. So yes, thank you for that very timely question.
I have to chime in there. I'm just thinking about a dear friend of mine that is, I was on a Zoom session with her yesterday, and she was showing me her partner's urn, and it's just sitting waiting because she's trying to plan a service, but of course she can't have anybody congregate to have a memorial. And I think that this is just a very sad time for families who have had someone pass. And my heart goes out to anyone who's deferring a service of any kind, how that must feel to have that happen in someone's family. So, and of course, there are people like that all over the country and all over the world now. So my prayers to all of them. The next question is, the attorney my mom used to, the attorney that my mother used to draw up her will, revocable power of attorney, and advanced directives or advanced healthcare directive did not want to draw up a living trust for her. Why would he not want to do that?
Well, one of the things that I have found is most of our estate planners are not long-term care and capacity planners. Most of them are thinking in terms of avoidance of probate, and most of them are thinking in terms of avoidance of estate taxes. So for small estates, sure, for small estates, a lot of estate planners think that a will is going to do it for you. But as I've emphasized, the revocable living trust allows someone to stand in your shoes, conduct business on your behalf, but also to take those steps to plan for your incapacity and for your long-term care. And so for that reason, it's very individualized. There's not a cookie cutter answer for every person's circumstances, but for the most part, I think you get different results with an elder law attorney because you have a different set of priorities.
Okay, thank you. The next question is, why do so many attorneys lead people to believe that Medi-Cal will pay for their care when they run out of money? It seems like they rarely explain that in Orange County, they can't qualify unless they are essentially bedridden and unable to transfer.
Right, exactly. So I think that's one of the issues with Medi-Cal planning is that one of our slides said that Medi-Cal is not our goal. It's our safety net. It's our last resource. It's our last resort when we don't have the resources or cannot qualify for any of these other programs. I think you and I said, this is not what you and I would wish for. None of us start out planning, I want to hit that nursing home. I'm going to have a great time there. No, this is our last resort.
Mm-hmm. Yeah, we see, so many caregivers who have been caring for so many years, and then it's just been gone on for so long, and they just want that, they need that placement so badly, but they don't understand that the person has to physically qualify. That's the part that's so tough to explain to them, that they really have to meet not only financial criteria, but physical criteria as well. So that's very difficult. That's very difficult to talk to families about. I'm an only child, no other family. In the 90s, I went on the home deed. We put the life insurance money, half mine and half mom's, into a joint bank account. We also added me as a joint owner. Okay, this sounds like it may be a personal question. I don't know if we can do those. Can we do those, Christina?
Well, I think I know the tone of the question, and I'll just generally answer.
She says the question is, since she's the owner on everything, can it affect parents' approval for Medi-Cal should she need to live in a SNF in the future?
Oh, okay. That was a different question than I would have guessed. I shouldn't have
I'm
presumed.
not giving all the information. It's kind of lengthy. I'm sorry.
Okay. Can you qualify for Medi-Cal for long-term care if you jointly own everything? And the answer is yes and no. The qualification is still the same. We said a house, a car, unlimited IRAs, and up to $2,000 for a single person, even if it's jointly owned. The difference is if it's jointly owned, then it's not subject to Medi-Cal estate recovery. Used to be, but not anymore.
Okay.
But that doesn't being joint owner doesn't give you the ability to make medical decisions for another person, nor does it give you the ability to stand in their shoes and conduct business on their behalf. So even in those circumstances where you have just a single child, jointly owned assets, I would still say that estate planning documents are necessary.
Okay, and then we have one final question, and then we're going to go ahead and close the webinar. The question is, how often can you change the people named in your trust? Is there a limit, and is it expensive? Oh, that's a great question.
Okay, so the way that you change the persons in your trust is determined by what it says you must do in your trust. So in my documents, when I do amendments to trust, we require a formal document that specifies what section of the trust is being changed, and it's notarized. So it's not enough just to interlineate with a pen and write on your original trust document. You must have a formal document that states, I'm changing this part of my trust. There's no limit to how many amendments you can do, but I recommend that, not more than, say, 3 amendments to a trust document, because then you have too many pieces of paper floating around, and then it's very difficult for your trustee to administer your trust. So I recommend after a couple of amendments that you just revise the entire document so you have a compact document that your trustee can take around town and conduct business on behalf of the trust. How much does it cost? It varies. Let's talk about estate planning and how much it costs. It varies. If you're in South County, you're going to pay a heck of a lot more than, say, Central Orange County. I've seen estate plans, say, Coto de Casa, and estate planners there, $6,000. I've seen estate planners in, say, the Laguna Woods area, much more affordable, somewhere around $2,000. So it depends on your personal needs. It depends on what kind of distributions you need in your estate plan. But I would say a good estate plan around $2,500 to $3,000. But the specific question was, what about an amendment? That I wouldn't be able to answer, because one of the things that we have in our community is if you go back to your same estate planner, they'll of course give you a discount because they don't have to start from scratch. But if you go to a new attorney, generally it's as though you're starting new.
Okay, a bunch more questions have come in. So I'm going to say that we can just take 1 or 2 more, and then we're going to, because of our speakers' time limitations and our own, we're going to have to end after that. And if you have to leave, everyone's met their time limit now, so I think we're okay. Don't forget to do your evaluation as required. So someone's asking, do you offer private advisement? If so, how can we book an appointment? And I don't know, do we want to put your number in the chat box, or do you want them to go through our helpline? Our
Sure.
helpline offers referrals to, we have a whole cadre of elder law attorneys, and we can give you Christina's number as well as others. I'll put that number in the chat box while our speaker is answering our next question. How does that sound for everyone? Also, let's see, what's our next question? Is advanced directives just a general term for living will, power of attorney, etc., or is advanced directive its own separate entity?
Oh, very good question. It's changed. So if you have an old power of attorney for healthcare, that's good. It also used to be known by the name living will. I think it was 1990 that they changed it to advanced healthcare directive. So any of these things are all one and the same. The newer document, the Advanced Healthcare Directive, which is a statutory form that you're going to see the same form over and over again. For example, Kaiser prints it out. A Blue Shield Blue Cross prints it out. The Five Wishes is a different format, but still valid. And also California Medical Association. They're all the same forms. And they're all now known as the Advanced Healthcare Directive. So my message is, if you have one of these old documents by another name, it's probably outdated because there's some slight things like HIPAA laws that are being addressed. I'd say it's about time to get a new one.
Okay, and a final question. How are trustees paid to administer a trust? By the hour or by percentage of the value of the estate?
Either. So most documents say the trustee can be paid reasonable compensation. And so what's reasonable is whatever the region, the geographic area says is reasonable. Here in Orange County, we say that a flat annual percentage of 1 to 1.5% is reasonable, or an hourly rate, $30 for most family trustees, or if it's somebody who's, I don't know, a hedge fund manager or, a CEO, something like that, maybe $75 to $100 per hour. Yes, it is a job. Being a trustee is most certainly a job, and compensation is usually allowed for in the trust.
Okay, with that, I'm afraid we're going to need to end our program for the day. It was wonderful. We want to thank our expert speaker, Christina McGonigle. I'm so sorry. I think I'm getting tired. Christina McGonigle, you were wonderful, and I thank everyone for staying on, and I thank you for staying over. As we leave the webinar today, don't forget to fill out your evaluation, and we will see you next month for our webinar on resiliency and coping strategy for dementia caregivers. Everyone have a wonderful day. Bye-bye.
Thank you. Bye-bye.